It's almost what?
We're back in the joint hearing with House Judiciary Committee and House Corrections and Institutions Committee. And we're now going to have a walkthrough of S-195. I believe everybody has received a copy of it or have it online. So back over to you, Ben. Thank you.
Thank you. Again, for the record, Ben Okrowski from the Office of Legislative Counsel. Before the committee is S-195 entitled an act relating to how a defendant's criminal record is considered in imposing conditions of release. Essentially, this bill proposes to do four broad things. One, change the bail limits for certain crimes, which is what I referenced before about removing that $200 cap for expungable misdemeanors. Adding factors for the court to consider in imposing conditions of release, most of which are already sort of implicitly considered by the court, but have been codified to ensure consistency. Adding new monitoring programs that can be imposed as conditions for individuals who qualify. Those programs include the expansion of home detention, the revival of electronic monitoring program, and the creation of pretrial supervision. And then also to create and clarify accountability mechanisms for those who violate conditions of release. I previously referenced that a VCR, a violation of condition of release, can be as a prosecution that can currently be commenced. This creates another proceeding in addition to that to hold people accountable for violating conditions of release. And then, as I mentioned before, building out that bail revocation statute to incorporate the case law in statute. So turning to the particulars of the bill. So Section 1 amends 13 VSA 7551, which is the imposition of bail, appearance bonds, and sort of their associated limitations. The portion here that really changes is you'll see on page 2, starting on lines 12 through 14, which is you'll read in subdivision 2, in the event that the court finds that imposing bail is necessary to mitigate the risk of flight from prosecution for a person charged with a violation of a misdemeanor offense that is eligible for expungement, the court may impose bail in a maximum of $200. This bill adds language that says the $200 limit shall not apply to an offense allegedly committed by a defendant who has been released on personal cognizance or conditions of release pending trial for another offense. So basically, if they're already charged with that expungable misdemeanor and then they're charged with another crime, that $200 cap doesn't have to apply in that instance.
Right. Is that evidence of guilt? Is grade standard part of this implicitly or not? No.
So that could be a violation of condition of release. Is that correct? Is that can be the additional offense?
There can be a condition to not commit a new crime, but it doesn't have to be. It's just if someone commits a new crime and they're already out on conditions, that expungable misdemeanor cap wouldn't apply in that situation. It's precisely that.
But if they violate a condition of release that they stay out past their curfew or they have contact or anything like that, that's not an additional offense for which the bail would.
That's not criminal conduct on its own.
Can I ask a question that kind of backs us up to before you even really dive into the bill? I'm realizing I don't know where this bill came from and what the impetus is. Like, I know there are all kinds of issues with bail and questions about bail.
So let me answer that because that's not so much. Legislative Council was asked to draft the bill.
Yes.
That's where that came from. So prosecutors have wanted to address these issues. So it comes from prosecutors. You will note that we have 3 bills in our committee on our wall. that were, I think, companion bills to what this bill ended up being. So those were introduced by some of our members, I think Tom Oliver for one. Tom has been particular, well, in fact, Tom, if you want, this comes from you as much as anybody. If you want to just give a quick, why are we doing this explanation? Yeah, I mean, it was in the Senate as well, but I know that Tom Oliver has really been pushing for this. Are you with us still? He may have gone to get some coffee or. Well, lucky him.
Yeah.
In any event, so we can hear from Tom later as well. We can get that from him. Yeah,
I'm here. I'm here. Sorry. I was,
Can
on
you
the
just give
phone.
a quick statement of why we are doing this, Tom? Why this bill is important? Why, I mean, I know that it started in the Senate, but I know this was companion bill to some of the stuff that you have in your bill. Could you
Right.
just give us a quick overview, a quick idea of why?
Well, I think sort of, looking at what you've said this morning and what I was used to before, and maybe the disparities that we're trying to fill, maybe my my goals might be different than others, but I think we're seeing an awful lot of people with smaller crimes on the streets reoffending, and I look at conditions and bail are very important tools to help maybe we don't need to put people in jail right away, but we need to let their behavior dictate, I think, where we're going to go with them. And it may be jail for short term to get them a little bit grounded and under control and get them back into a good place, even if it's a week or two in between incarceration and a bail review, maybe, and reassess where they're at, something like that. I think releasing people on citations and when we pick them up on a warrant at night because we can't bring them to a court or take them to jail and they just reoffend, it's not working. I'm personally seeing it's affected my job greatly. And it wasn't like this before 2018. I don't know what's changed. And the only thing I can think of is what we've tweaked with the bail stuff. Before, someone's behavior, it wasn't unusual to see people for nonviolent felonies being held on bail and some, or the harsher misdemeanors for periods of time. And sometimes I think it was very beneficial. I wish there were more services in jail, which there aren't. I mean, it looks like we're going to have maybe work crew back, which I think is a serious bonus, but it doesn't fix the problem where people are not really taking that step forward and wanting to get better. And I think the only way we can do that if they're not doing it on their own is intervention. And sometimes that has to start with some sort of incarceration, but until we have better services, I don't know the answer. I just know that we are having epic numbers of reoffense. And that's not good.
Right. So I would also just add in the testimony we've taken on the retail theft bill, on other bills that we've looked at this session, a common refrain has been that people are violating conditions. There's a lot of repeat offenders, et cetera. I don't think that this bill necessarily is going to lead to more incarceration. That may have been part of what Tom thinks is part of the answer, but we're looking at some other, supervision in this. We'll get to.
Yeah.
We're looking at in-home detention. We're looking at ways to kind of tighten the supervision of individuals who are on conditions to try to keep them on.
That's what I guess was when I started out. Is there something in the middle? There's a gap in there that we're missing, or whatever. And I'm certainly more is going to help at least a little, but it could help a lot. And unless we try, we're not going to get anywhere.
Right. Yeah. All right. Thanks, Tom.
Thank you.
Thank you.
Back over to you, Ben.
Yeah, and just,
Yeah, Joe, sorry.
I've been sitting here for a few minutes, like, wrestling with why this sentence on page 2, lines 12 to 14 bothers me. I still don't know exactly, but I do have at least a question maybe to help myself figure it out. So like the purpose of cash bail is to have someone come back, right? Like that's it. Like it's, come to court, don't avoid prosecution. And like putting aside the question, which I don't know why like this limit was put there in the first place. I guess I'm sort of like trying to figure out if at some point the legislature decided misdemeanors are capped at 200 and that is sufficient in order to get someone back, then why, if they didn't otherwise violate their conditions of release or anything like that and happen to commit an expungable offense, and I think that's something that we have to also change in this here, I think should say expunged or sealed, considering the work that we've done in other areas, like why the limit like wouldn't be there for that, like why it would make a difference. The only point is to get the person back in, then why the fact that they happen to be out on personal recognizance would make the 200 not apply there. It's probably more of a policy question, I think I've answered my own question there, but I guess I'm just throwing out there seems to be an incongruity between this sentence on lines 12 through 14 and the stated purpose of cash bail, that the discussion.
I think what may or may not help is when you get to page 24 of the bill, which changes somewhat the definition of flight from prosecution.
Okay.
So if we consider them individuals violating their conditions of release, particularly by committing additional crimes, can that be defined as flight from prosecution? And the $200 is not, in my view, or you can look at more. And still, a question I would have is that there's still the means test for determining what would be an appropriate bail, because it should be something that they shouldn't be excessive still, even if it's not $200. But is it more incentive to not have flight from prosecution in the broader definition of what flight from prosecution is? Is that about? Is that?
I think that could be one way to think of that.
Okay.
Yeah.
Okay. Wayne.
So just the way tell me if I'm thinking of it. So that 200 limit shall not apply, which means that the court can give a higher limit, but the court could also could decide that we're going to give them 200.
They already have
They already have
They
that.
already have 200.
I know, but that's required, right? So
Right.
with this, it's taking off that limit
For a new offense,
for
for
a new
another
offense. But
offense.
for that new offense, it does not prescribe a $200 limit, but the court could do anything it wants.
Well, so it doesn't have to impose $200. It just may impose bail
Which could be
to the
1,000.
maximum of $200 currently. This would remove that limit for a new offense that is committed.
But they could make it higher. They could still set bail and it could be more.
If this
Depends on the
were,
offense.
if this were to pass?
Yeah.
Yeah, but this would be, yes, it could be in excess of the $200.
Right.
Yeah.
But if they decided that 200 was enough, they could apply 200.
Yeah, they'd have discretion. There wouldn't be any prescription one way or the other for that specific circumstance. And just for some context about sort of the evolution of this bill that I think is helpful. So there was also a companion bill in the Senate, S-287, which was sort of rolled in part to S-195. That bill had some accountability measures that led to incarceration, but due to some constitutional issues with that, the mechanism was rolled in. The additional accountability, new accountability proceeding was rolled into this bill, but the sanction was changed from incarceration to essentially imposition of conditions of release and new program. That's helpful. So that's really the change to section 1. In section 2, this amends 7554 of Title 13, which I previously referred to as the Bail Bible. This, you'll notice some gender neutral and terminology updates, but really the big change regards the factors that are included in the court's analysis, and then also the conditions that can be imposed. So I'm going to start with the conditions in the first part of the analysis that we discussed. So on the top of page 5, lines 1 through 4, the electronic monitoring program and the home detention program are now conditions that can be imposed related to bail. You'll see if you scroll down onto the next page, those conditions are also added to the public protection factors in the second part of the analysis. And then if you scroll down even further to page 7, lines 8 through 13. So this subdivision is what's considered in those public protection considerations. So right now, it's adding to the current considerations of nature and circumstances of the offense and weight of the evidence accused. The court can now consider the number of offenses with which the accused is charged, whether the accused is subject to release on personal recognizance or subject to conditions related to protecting the public in another case pending before federal or state court, whether the accused is subject to conditions related to protecting the public for probation, parole, furlough, or another form of community supervision, and whether the accused is currently compliant with any court orders. These are new factors in addition to what's already considered that there's been testimony saying are largely sort of implicit in the court's analysis, but this makes it explicit in the statute that these would be considered in this part of the analysis across the board. Any questions about the addition of those factors?
Okay.
Not on those factors, but just going, and this might be in testimony, when you're talking about conditions that were added for bail and then for public protection, the electronic monitoring, and I think you shared this in your slides too, that is the revival
Yes.
of electronic monitoring. So was this a practice that was used and then it was removed? And if I can just have a little bit of the history, which I know is probably controversial, but it's probably helpful.
Well, I will give my depth of knowledge and ask the Chair Emmons, because she's an encyclopedia when it comes to these. But basically, I believe it was in 2017, was it the Windsor or Wyndham County Sheriffs? Wyndham County Sheriffs had a pilot program of electronic monitoring that, from all everything that I've heard, was successful to a degree. It was just a pilot program that sunsetted essentially. And this is a revival of that and an imposition of it statewide.
So it never was implemented statewide,
Correct.
and then, okay, that's helpful.
Well, home detention, folks who are currently in home detention are on electronic monitoring that's administered through the Department of Corrections. And it is a passive electronic monitoring. It's not active, so it's not real time. It's after the fact.
Right, but I think was Representative Dolan, you were asking about the electronic monitoring program itself, right? Yeah, because electronic monitoring is part of home detention as well, but this as an independent condition of release is something that's new statewide.
Wasn't there like an equipment issue or something?
It was, we took care of that last year. The Institutions Committee took care of that.
I think something about I feel like there was a price issue.
The price issue was because it was active, we needed more correctional staff on staff over time. By going passive, you didn't need as much staff. And the other issue too that was playing in, people needed a landline, and very few people now have landlines. So last year we allowed cell service for that.
Moving on to section 3, because that really is the substantive changes to section 2 bill. Section 3 is the expansion of the home detention program. So this amends 7554B of Title 13. And if you scroll to page 11, this is really where the first substantive changes are made to the procedure. So you'll now see that in addition to the court, DOC, and the defendant, the prosecutor is added to as one of the people that can request a review for the appropriateness of home detention. And that is because the eligibility has been expanded to now include a defendant who has allegedly violated conditions of release or of personal recognizance, not just those who are held for failing to post bail. So it expands to those who have violated conditions as well. And so that's why the prosecutor can now make the request for the court to do eligibility determination, essentially. And you'll see farther down on the page on lines 16 and 17 that, the term assure his or her appearance in court when required is changed to mitigate the defendant's risk of flight. That is just to keep it in line with the defined term. This was probably just a Scrivener errors in the past that was not caught. And without going back through the determination of home detention, you'll see that on page 12, subsection C is amended. This is the failure to comply. So you will recall that previously DOC had the discretion to recall someone to incarceration for a violation. What this now does is that DOC may now report a defendant's unauthorized absence or failure to comply with a condition of the program to the prosecutor and the defendant, provided that a defendant's failure to comply with any condition of the program for a reason other than fault on the part of the defendant shall not be reportable. So essentially, if someone, couldn't make a medical appointment, or their car died, or there's some other extenuating circumstance, that wouldn't count as something that would be violative. To address a reported violation, the prosecutor may initiate a review of conditions under the bail statute 7554. A violation of conditions proceeding pursuant to section 7554E, that's that new proceeding that I explained that I'll get into in a bit. A prosecution for contempt under section 7559 of this title, that's the current enforcement mechanism for a violation, or a bail revocation hearing under section 7575.
Wait.
So we're shifting the responsibility from DOC to the court. So.
No, DOC is still responsible for
Oh, no, but-
overseeing these individuals, but the court is ultimately the.
Decider.
Yes, exactly.
So we have a court problem already. We have a court problem with things not being able to get through the court. This is going to make it worse.
It may. There's testimony also that it could also help, because what that testimony has said is that every time someone is brought to court, that's another chance to confer and either negotiate a plea agreement or expedite resolution of the case. So on the one hand, yes, it would add to the court's docket, if you will, but on the other hand, it may expedite resolution of the case.
I don't have an answer, but I'm just wondering if what you're seeking to accomplish might be written into what DOC is required to do in these kind of cases.
What do you mean by that?
Let me get back. Let me think about it a little more. But I'm just wondering if there might be another remedy or another solution.
Well, the reason that this was discussed as being needed to change is because since you're changing the eligibility, so it's being expanded from those that would otherwise be incarcerated if not for the home detention program. This now includes other people now that wouldn't have that threat of incarceration. They've just violated or allegedly violated conditions. So now you're talking about a more restrictive condition, because think about it. Home detention next to imprisonment is probably the most restrictive condition that you can impose on someone. So you really have to balance that through the court. You can't give, I think there would be constitutional issues if you gave DOC full discretion to revoke home detention for those individuals that would otherwise be out on bail. So I think that there needs to be a process separate and apart from DOC's discretion in this instance.
Okay, I can buy that.
Tom Oliver. You're on mute.
Sorry, I'm just trying to catch up, a little bit distracted. So you're looking to add home detention to the list of possible things to do for conditions of release. Is that it? Pretrial?
Yes.
Yes.
Yes, it's added to the list of conditions.
Oh, okay. And so I guess what would be the sanction ultimately? There, we need something, you know, if they completely ignore home detention, what are we going to do?
So those are enumerated on, the four options are on page 12,
Okay.
11 through 15. So there can either be another bail hearing where the court would assess someone based off of the conditions outlined in 7554. There's the new proceeding that I'll get into. There's a contempt proceeding, or bail could be revoked pursuant to 75 altogether. So those are the four accountability mechanisms, if you will, for an alleged violation.
Okay, so I'm just procedurally thinking home detention is going to be in lieu of incarceration, but there's still going to be the ability to set bail.
Yes.
You're going to have bail, but they won't go to jail. They'll go to home detention.
Well,
Home detention started as a way to release pressure in our incarcerated setting in holding detainees. So
Yeah, I
they're a
think I was.
detainee, so instead of holding them in a correctional facility, they're being held at an appropriate home setting.
Right. I think I was in the very first hearing when it was done, to be honest with you. I'm just trying to, are they going to still set bail in this circumstance that you're only going to be in home detention versus incarceration?
they could. I mean, there's nothing that would restrict the imposition of bail if you're confined to home detention.
Right. So if somebody was confined to home detention versus incarceration, I think it would be very beneficial that if we had a reasonable bail set, they knew the consequence for ignoring their home detention. And then they could have their bail revoked. If there's no consequence, I feel we're just, chasing a rabbit down the hole. That's my concern.
And I hear you, Representative Oliver, and these four procedures is that accountability, that consequence for violation of home detention.
Mm-hmm. Okay.
So it can be imposed as a condition of release if you're suitable.
Yeah.
If you violate, then these four mechanisms can hold you accountable for that violation.
Okay. Yeah, good. I haven't read that yet. I'm jumping in late here.
So that's okay.
But thank you. I appreciate it. Thank you.
So going forward, you'll see an addition of subsection E at the top of page 13, which outlines program support, that the department may support the operation of the program itself through grants of financial assistance or contracts for services with any public or nonprofit entity that meets the department's requirements. So basically, they can contract out if they don't have the staffing to operate the program itself.
Wait. Skip back to where we were a second ago, where
To the violation or the
yeah, the
failure to comply portion.
because when someone's in prison and they violate what they're, if they do violations inside the prison, they do things wrong inside of the prison, DOC has the ability to take action.
Right, because they're under the custody of the department.
These are under the custody of the department. Also, no?
No, they're under the supervision. Like so it's not, it wouldn't be custody per se.
Not sentenced yet.
Yeah,
Oh, these are not sentenced. These
They're
are-
not-
no. So this is
Never mind. Okay.
pre-trial. So everything here is pre-trial before sentencing. So while DOC is the entity that's being used to supervise these individuals, but they're not under the custody of the department at that point.
I was thinking that they were sentenced. I was on the wrong track.
Karen?
This is not regarding what Ledge Council shared, but just curious what the path is going to be for this bill.
Well, we're working on it.
In what sense?
Of which committee? Because I just was looking it up. I was like, oh, what committee is it in?
It's gonna go to us.
But we're gonna work on the DLC parts.
And we have to decide if you actually are gonna take jurisdiction or not,
Right.
hopefully not, but.
We'll
you know,
work it
just-
out.
Yeah,
Okay.
yeah.
It
So,
might be like 5.
Just tell me where I need to go and when.
Yeah, we'll tell you where you need to go.
Nicely.
And speaking of that, we've got an amendment to one of our bills on the floor this afternoon. So about 11:45, we're gonna have to scoot.
Yeah, we'll finish up by quarter to 12, even if we have to come back to you.
So we finished home detention with that program, addition of program support. Section 4 is the addition of that new proceeding to hold people accountable. So basically, the court may determine that a condition of release was violated upon notice and a hearing to the defendant. And this is on for orientation is on page 13, about a third of the way down. Whenever a defendant's alleged to have violated a condition ordered pursuant to 7554, the defendant may be arrested or cited in accordance with rules 3 or 18 of the Vermont Rules of Criminal Procedure to appear before the court in which the conditions of release were ordered. A judicial officer has discretion to issue a warrant for the arrest of a defendant charged with violating a condition, and the defendant shall appear before the judicial officer. The defendant alleged to have violated a condition may appear not later than the next business day following the arrest or citation. This is commonly known as a flash cite. And this is done, I believe, in relief from abuse orders or RFAs. So this creates a procedure where someone who's alleged to have violated appears the next day, which was a very, I would say, purposeful policy decision made by the Senate Judiciary Committee to get someone in front of the judge as soon as possible. The prosecutor may also request, so at this appearance, there are a couple options that can occur. The judicial officer may review and modify the conditions of release under 7554, but the prosecutor may also request at the hearing that a judicial officer schedule a summary hearing in accordance with subsection B of this section, or elect to commence a contempt prosecution. But you'll see later on, they've got to choose. It's an exclusive remedy. They can't pursue both a proceeding under this section and a contempt proceeding. So that's a choice that the prosecutor needs to make. So at this hearing,
What makes something a summary hearing rather than a regular hearing?
it all is handled like sort of at once.
Okay.
But I think there is a more technical definition that I would need to look up.
I think that's fine. I'll handle it one
Yeah,
time. Good with
and
that.
perhaps my colleague Zone can give you a little bit more explanation than I can at this moment.
Okay.
So upon request, they can schedule that summary hearing to determine if the defendant violated a condition of release. The state has the burden of proving a violation by a preponderance of the evidence. You'll see information stated in or offered in connection with any order need not conform to the rules of evidence. So it is treated much like a bail hearing where the rules of evidence don't apply, but the judicial officer does have discretion to take live testimony if deemed necessary. So doesn't need to adhere to the rules of evidence, but the judge can make the call and say, we want to hear live testimony about this to really, and that would help adhere to the rules of evidence. So let's just say it's failure to, rules of evidence don't apply, plus a little bit. The judicial officer shall issue an appropriate order addressing the alleged violation pursuant to subsection C. So there are a few ways that these violations can be disposed of. The judicial officer needs to consider various factors. If the violation of a condition does not otherwise constitute a crime, if it does otherwise constitute a crime, the nature of the underlying offense that the defendant's charged with, basically the defendant's criminal history, prior convictions, history of violence, medical, mental health needs, history of supervision, risk of flight, and any risk that the defendant poses to the public. So upon a finding by the court that someone did violate a condition of release, the judicial officer must impose the least restrictive condition or combination of conditions to reasonably ensure the defendant's court appearance, mitigate the risk of flight, or to reasonably protect the public. And that's a new factor, really, that can be considered in the imposition of these conditions. And again, you'll see that they can use 7554 to impose those conditions. So it's from that list again, or the person can be placed in a pretrial supervision program pursuant to new section 7554G, which I'll get into momentarily. But if the court determines that a violation condition also constitutes a new crime, the prosecutor may also pursue bail revocation. So there's another level of discretion permutation that can hold someone accountable depending on the evidence and prosecutorial discretion. And you'll see subsection D at the bottom of page 15 is that exclusive remedy provision that basically the prosecutor needs to choose one enforcement mechanism or the other.
So just if you could summarize, what does 7554E give us that's not 7554?
Well, I think it's probably what's not in 7559. 7559 is right now the only real enforcement mechanism, and it's a prosecution for contempt of court for a violation of conditions. 7554, I mean, I suppose that that conditions can be modified at the request of the prosecutor or the defendant, sort of at their behest. And then the court can then impose further conditions, but there wouldn't really be sort of a greater accountability other than 7559, which is a separate criminal proceeding, prosecution to hold them in contempt. So this is essentially a second enforcement mechanism alongside 7559. And I would say it's a policy consideration for the committee about the value of having a second proceeding alongside 7559. Does that make sense? Because 7554 is really the bail conditions. And I think that the purpose of this in 7559 is a little bit different. It's really to hold people accountable for a violation of conditions, not just giving the court discretion to impose more, because it permits them to do more.
So was there consideration of just modifying 7559?
There was testimony from Judge Zone, I think, about that possibility.
Okay, so we'll
It was discussed, but this was what was decided.
Okay, all right, thanks.
Section 5 is the revival of the electronic monitoring program. The language in this largely mirrors the language that had previously sunsetted for the pilot program. The intent of the program is to assist with ensuring the defendant's compliance with conditions of release, mitigating a defendant's risk of flight, or reasonably protecting the public. You will see those three phrases repeated many times in this section because it's really the purpose of it. Program and administration, DOC, shall expand and manage the electronic monitoring program for the purpose of supervising persons ordered to be under electronic monitoring as a condition of release, in addition to or in lieu of the imposition of bail pursuant to 7554 of this title, or placed on home detention pursuant to the home detention statute. The department may support the program's monitoring operations through basically contracting with third parties that are public or non-profit entities. The procedure is that the court, the prosecutor, or the defendant may request that the court determine the appropriateness of someone to be placed into the program. After a hearing, the court may order the defendant be placed under electronic monitoring, provided that the court finds that placing the defendant under electronic monitoring will assist in ensuring compliance with conditions, mitigating risk of flight, or protecting the public. And this is, we're on the top of page 17. in making a determination, the court considers.
Sorry, right on.
Can I just wanted, it just caught my attention in section 2 on page, at the bottom of page 16. I'm assuming this is deliberate with any public or nonprofit entity, so that exclusively prohibits us from using for-profit.
Correct.
Okay,
Yeah.
That was a specific change.
thank you.
So in making the determination, the court considers the nature of the offense, criminal history, and any risk or undue burden that the person poses to someone residing at their residence, risk to parties, or risk to public safety that may result from the placement into the program. The department is charged with establishing written policies and procedures in a manual to be used by the department, any contractors or grantees that engage with the department and the courts. And then failure to comply with conditions of the program. The DOC may report a violation to both the prosecutor and the defendant, provided that the defendant's failure to comply, again, is not their fault, basically. To address a reported violation, the prosecutor has a few options. Review conditions under 7554, pursue a violation of conditions under the new proceeding, pursue a prosecution for contempt under 7559, or to hold a bail revocation hearing. So again, similar accountability rules, but just through different programs and that can be imposed on the individual. So this would be to hold them accountable for violations of that program.
So if DOC contracts out for these services, I'm understanding that that service would realize there's been a violation. Then they would report to DOC.
They would report to, well, I guess
And then DOC.
it's not detailed specifically, but presumably there's always dangers in presumably.
Yeah.
That, yes, it's the department's obligation. Well, not obligation, they have the discretion to report. But yes, if they contracted with them, they would be a contractor with the department. Presumably, they would need to abide by the department's own requirements.
Okay. But we'll do some work on that.
Sure.
That's where some of the issues happened before on the pilot, because the concern was who has jurisdiction over the person? Is it the entity that's supervising them? Or is it the entity that is providing that contract to that private provider?
Right. I mean, and again, another presumption is that there's still the policies and procedures manual that would be provided to these contractors. I really would hope that the Department of Corrections would address that specific issue, but yes, that's also something that could be more specific. Any other questions? All right, let's get to pretrial supervision, section 6. So this is halfway down page 18. For the purpose of pretrial supervision, very similar. Assist eligible people through the use of evidence-based strategies to improve pretrial compliance with conditions, to coordinate and support the provision of pretrial services when appropriate, to ensure attendance at court appearances, and to decrease the potential to recidivate while awaiting trial. You'll see that there's a definition of absconding that's been incorporated here. Chair Emmons, and Representative Morrissey may be the only ones that recall dealing with that definition a couple of years ago. So it is now incorporated into this statute. So pretrial supervision, what is it? It's to supervise defendants who violate conditions of release pursuant to those two enforcement mechanisms. The new one established under 7554E or the contempt prosecution. Or for those who have not fewer than 5 pending dockets before a court, pose a risk of non-appearance at court proceedings, pose a risk of flight from prosecution, or pose a risk to public safety. So those are the people that the program is meant to supervise.
So I assume that 5 pending dockets is to not have everybody shipped to this program. It's just the higher needs individuals.
Correct. I believe that was the policy consideration.
Okay.
So this is adding a layer that doesn't exist right now.
Correct.
Which part?
The whole thing.
Barbara,
And
So start with the pre-trial, right, that you and Brett Morrissey did?
Well, so
The absconding,
That's what?
that's what the absconding.
yeah, don't, that was just the absconding definition. I wouldn't, the whole pretrial supervision program is new.
It's new.
Right. And then the layer, I believe that Representative Dolan was referring to is who's eligible for such a program. So it's not just going to funnel people who are arraigned and subject to a bail hearing right away. It's only if you've violated and been adjudicated under the 2 enforcement mechanisms, you have not fewer than 5 pending dockets, or you pose a risk of non-appearance, risk to the public, or what have you. So it narrows the funnel, if you will, about who gets into the program.
So what I'm looking for, just so this is flagged, which I've never used that word in 6 years. But conditions of release isn't working, which is contributing to our court backlog, I think. That's just what's going through my mind, okay? That's why I brought that up and where this language is coming from and all that. Thank you, sir.
Barbara?
So when Representative Dolan asked her question about a new layer, I was thinking she meant a new layer of like Department of Corrections being involved pre-adjudication, pre-trial. And you're saying that that's narrower for people. So not everybody who is pre-trial would be eligible for something under DOC.
For the pretrial supervision program specifically. Correct.
Right. Just that narrower group that you just were saying.
Yes.
And I feel like the last time we had a joint hearing, or one of the times, we were talking about how DOC's role usually is not involved
Not involved with what?
Pretrial.
pre-trial.
Well,
Well,
So I just want to kind of figure out, is this a new
yeah, and.
yes and no? Right?
I mean,
Yes
so
and no.
they are involved in that there are people being detained, and they're
and
That's true.
in home detention.
Right.
And the way I look at this is that these are individuals who perhaps could use some more supervision. And if you look around, who are you going to assign for supervision? And DOC just seems to be the
And
choice.
correct me if I'm wrong, but like in some other states, the courts have staff that do, like it's in a more neutral.
Yeah, and it's
Spot.
just probably a history of policy decisions to get to this point where.
Yeah, I just
Why
kind of want to,
DOC has assumed some of these roles as opposed to expanding the court's role in supervising such individuals.
because we also talked about it, diversion, right, with trying to, yeah, so, okay, I just want to kind of name it and say it.
I think you also have to remember, post adjudication, people are on probation. They're under the court, DOC supervises.
I know, right.
So,
Right? You have a question?
Same thing with furlough.
furlough, they're under DOC.
Right, that's right, okay, yeah.
So just getting into that supervision aspect, so DOC is responsible for supervising those placed into the pretrial supervision program. The department shall assign a pretrial supervisor to monitor defendants in a designated region of Vermont and help coordinate any pretrial services needed by the defendant. So that's another role about basically putting them in contact with the supports that they may need as well. The department shall determine the appropriate level of supervision based on evidence-based screenings of those defendants eligible to be placed in the program. The supervision methods include use of the department's telephone monitoring system, which my understanding is it's essentially an automated system notifying them of appointments and things like that. Telephonic meetings with a pretrial supervisor, so just over the phone, in-person meetings, or any other means of contact deemed appropriate, which could include FaceTime or Zoom calls, things of that nature. So it gives them discretion and also doesn't necessarily require certain levels of supervision, and that's largely to accommodate maybe the landline and cell coverage and other things like that, connectivity issues. If the court determines that the defendant is appropriate for the program, they issue the order placing the defendant and setting the conditions of supervision. So the court can sets the conditions of supervision, and the department basically has the discretion on how to carry that out. At the request of the court, so this is the procedure now, that the prosecutor or the defendant, at the request of the court, the prosecutor or the defendant may be reviewed to determine if they're appropriate. The review is scheduled upon the court's receipt of a report from DOC determining their eligibility. This is kind of similar to the home detention process. A defendant held without bail pursuant to 7553 and 7553A are not eligible for pretrial supervision. A defendant is eligible if they violated conditions pursuant to section 7554E or the contempt statute, have not fewer than 5 pending court dockets, poses a risk of non-appearance, a risk of flight, or a risk to public safety. The court may order the defendant to be released, provided the court finds placing the person under pretrial supervision will essentially ensure those things. And in making such a determination, the court shall consider the nature of the violations, nature of the circumstances of the underlying offense, defendant's criminal history, and any other factors deemed appropriate by the court. Subsection E, this is compliance and review. Pretrial supervisors shall notify the prosecutor and use reasonable efforts to notify the defendant of any violations of program supervision requirements committed by the defendant. The reason why reasonable efforts was included, there was discussion within the Senate Judiciary Committee about if someone is unrepresented and they may not keep their address and contact information up to date, that basically you do the best you can to contact them. Upon submission of a pretrial supervisor's sworn affidavit by the prosecutor, the court may issue a warrant for the arrest of the defendant who fails to report to the supervisor, commits multiple violations of supervision requirements, or is suspected of absconding. So that's really the only time there's a distinction between pretrial supervisors notifying the prosecution and defense of any violation, and then a prosecutor's ability to actually enforce those violations. So it's a little bit of a higher bar for the prosecutor to really initiate that arrest or request for arrest. And then the defendant, again, is flash cited to appear the next business day following the arrest to modify the defendant's conditions. And then at the request of the court, defendant conditions may be reviewed. The court may also issue an appropriate order in accordance with the following. So this is basically like an assessment of compliance. If someone is compliant with all conditions of the pretrial supervision program for at least 90 days, they may receive a reduction in their supervision level or may be removed from the program altogether. However, if a defendant does violate the conditions of the program, they may receive an increase in supervision level or other sanction permitted by law. And then subsection F was added that the whole program is contingent on funding. So basically, if the program's not funded, it's not operating.
And those funds could come from grant monies or state budget.
Appropriation. So the pretrial supervision program established in this section shall operate only to the extent funds are appropriated for its operation. And then
Are you implying we don't have money to run government?
I'm not implying anything.
Oh, I just checked.
Policy note.
That's a policy
I know.
consideration.
Yeah. Ooh, it's quarter up. Yes.
You have 2 minutes.
2 minutes.
2 minutes, I can do it.
I got one little.
Oh, well, all right.
We're on the home stretch.
No, I just disrailed you.
I'm not taking questions.
I'm just, it's actually not a question, I'm just lagging, like Ken, page 18, line 18, where it says the pretrial supervision program shall supervise defendants, but later on, obviously, there's discretion there. And so I wonder if it should say, upon court order, this pretrial supervision program shall supervise, just to make that, because as it currently reads in that section, it seems to be they have to do it But they only have to do it if they're ordered to do so. So I'm just flagging that for later discussion.
Okay.
And I'm not reading anything in here that, that says this, but I want to be clear that the pretrial supervision, program is not, electronic monitoring. Doesn't include electronic monitoring.
It's not electronic monitoring at all.
All right, so I suggest we'll be back here 10 minutes after the floor and we'll give you 10 minutes to go over the last couple of things because I'm sure there's going to be some questions on the revocation of the right to bail. I don't want to rush through that.
I mean, that largely just incorporates the current case law.
Yeah, but I think we need to really make sure we understand that's the critical position, portion. But then we'll also be hearing from Commissioner Demmel and hopefully the floor won't take too long. Hopefully you won't have a bunch of questions on or your compatriots in your party. Well,
Just so you know, I'm not here after 3 o'clock.
you're not here after 3 o'clock. All right, so we will take this up when we get back to it on Friday. I guess we can just separately do that.
Right, but this afternoon.
But this afternoon, we're gonna have Commissioner
We're
Demmel.
both back here. So corrections and institutions is back here at 3 o'clock
I
here.
mean, I can very briefly just give a very general overview right now of the remaining sections if you'd like.
All right, yeah, I mean, go ahead and if you need to,
I'm gonna skip over.
they need to go, but
We have another.
I have to
You
repeat
can
it.
watch the video.
So are you available Friday morning to